Welcome to this clip on the notion of state aid. After watching this video, you should be able to define the notion of EU state aid within the meaning of Article 107, Paragraph 1 of the Treaty on the Functioning of the European Union. And you should be able to explain the 4 state aid criteria. Let us first turn to the relevant legal basis. Article 107, Paragraph 1 TFEU, which reads as follows. Save as otherwise provided in the treaties, any aid granted by a member state or through state resources in any form whatsoever which distorts or threatens to distort competition by favoring certain undertakings or the production of certain goods shall, insofar as it affects trade between member states, be incompatible with the internal market. This treaty provision clarifies that, in principle, member states may not grant state aid. In some of the following clips, we will see that the EU treaties also contain derogations from the EU state aid ban, which is therefore not absolute. For the time being, we will, however, focus on the notion of aid, which can also be derived from the treaty article and which has been clarified by the EU courts in their case law and by the European Commission in its notice on the notion of aid. A measure constitutes state aid within the meaning of Article 107.1 TFEU when it meets 4 cumulative criteria, the so-called state aid criteria. First, the measure is imputable to the state and is financed through state resources. Second, the measure provides a selective economic advantage to one or more undertakings. Third, the measure distorts or threatens to distort competition on the market. And finally, the measure potentially affects trade between EU member states. Let us go into each of these state aid criteria a bit more in detail. Criteria number 1. The measure is imputable to the state and is financed through state resources. This first criterion entails that for a measure to be considered state aid within the meaning of Article 107.1 TFEU, it has to be financed through state resources and imputable to the state. State resources include all resources of all public authorities of a member state, regardless of the level of these authorities, be it federal, regional, or local. More specifically, aid granted through state resources means aid granted through resources under control of the national authorities, even if those resources do not enter the state budget. Also, no distinction is made between aid granted directly by the state or indirectly by public or private entities, established or appointed by the state to administer aid. The criterion is met as soon as the adoption of the measure leads to a loss of state resources. Attributable to the state is a measure that is financed by the state, following a decision of the state to grant aid. Again, irrespective of which government level adopts the decision, federal, regional, local, etc. However, aid measures are not imputable to a member state when the latter is obliged to implement an EU obligation without having any discretion with regard to their implementation. Criterion number 2. The measure provides a selective economic advantage to one or more undertakings. The concept of economic advantage is interpreted rather extensively by the EU courts. An advantage is deemed to be relevant under Article 107.1 TFEU when it potentially relieves its beneficiary of costs that the latter would have to bear itself under normal market conditions. It is not the form or the purpose of a state aid measure, but its effect that is relevant to assess whether the measure entails an economic advantage. When a public authority enters into economic transactions with one or more undertakings, such as buy or sell agreements, capital participations, loans, rental or service agreements, it must take into account EU state aid law. It is indeed well established that such transactions may confer an economic advantage on the contract party or parties concerned. To verify whether this is the case, the public authority's actions must be compared against the behavior of a private actor in the same situation. This is the so-called market economy operator principle. If a state measure entails favorable conditions that a private undertaking would not accept, this measure is deemed to imply an economic advantage. Depending on the type of transaction, there are diverse forms of the MEOP test. For example, the private investor test, the private lender test, or the private seller test. State aid within the meaning of Article 107.1 TFEU exists only when a member state favors certain undertakings or sectors over others that are in a comparable factual and legal situation. In other words, when the measure is selective. A measure can be selective de jure. In this case, the selectivity of a measure results directly from the legal criteria for granting the aid. For example, undertakings from a certain size or undertakings that are active in a certain sector. A measure can also be selective de facto. In this case, the selectivity results of conditions or barriers imposed by the member state, preventing undertakings from benefiting from the measure. For example, by applying a tax measure only to investments exceeding a specified threshold. Measures that favor all market players, for example, a general corporate tax reduction, do not fall under the scope of the EU state aid law. Finally, it is important to know what is meant by the concept of undertaking, but this will be explained in a separate video clip. Criterion number 3. The measure distorts or threatens to distort competition on the market. If a measure taken by a member state perpetuates or strengthens the competitive position of an undertaking, it is deemed to potentially distort competition. Thus, in practice, this third criterion is met when a member state grants a selective economic advantage to an undertaking that is active in a sector where there is or could be competition. The Commission is in no way required to demonstrate effectively that the measure may distort competition. Criterion number 4. The measure potentially affects trade between EU member states. Trade between member states is deemed to be potentially affected where a measure results in an improvement of the competitive position of the beneficiary or the beneficiaries. The beneficiaries, however, do not have to be active in more than one member state. The granting of aid to an undertaking could make it more difficult for its competitors from other EU member states to enter the beneficiaries' markets. Therefore, trade between member states is potentially affected. The threshold for this criterion is rather low. Only in very exceptional cases the Commission has found that under the given circumstances of these cases, the measure concerned did not have more than a marginal effect on the conditions for cross-border investment or cross-border establishments. In summary, a measure constitutes state aid within the meaning of Article 107, paragraph 1 TFEU when it meets 4 cumulative criteria. First, the aid measure is imputable to the state and is financed through state resources. Second, the measure provides a selective economic advantage to one or more undertakings. Third, the measure distorts or threatens to distort competition on the market. And fourth, the measure potentially affects trade between EU member states. The Commission notice on the notion of aid provides guidance on how to interpret the state aid criteria. We also remind that the notion of state aid is continuously evolving and that clarifications can be found in the EU case law. This brings us to the end of the clip on the notion of state aid. Thank you for your interest and attention.